Hello, and welcome to the Pennsylvania State Nurses Association online child abuse program, an overview for mandated reporters. This program is approved by the Department of Human Services and does count toward Act 31 credit. Please note that no one on the planning committee or any presenter has any conflict of interest in relation to this activity. Successful completion of this program includes watching the entire video, completing the post-test, and submitting the evaluation with all requested information at the end of the program. Let's begin by looking at services for children. Within the Department of Human Services, there are two main service lines for children. One is Child Protective Services, the other, General Protective Services. In Child Protective Services, their goals include protecting children from further abuse, preserving and/or stabilizing families, prioritizing the response and services to children most at risk, and encouraging a more complete reporting of suspected child abuse. Please note that while we often get pictures in our minds of people knocking on doors and removing children from homes, that is not the overall goal of Child Protective Services. The overall goal is to truly preserve and stabilize families. Therefore, reports of suspected or known child abuse may actually serve to help stabilize families and provide resources that are not currently available. General Protective Services include goals of protecting the safety, rights, welfare of children so they can grow and develop in a healthy way, assisting parents in recognizing and remedying conditions harmful to children, and protecting children that are without parental control, habitually truant from school, or without justification, etc. The overall goal of General Protective Services is protecting the welfare of children outside of child abuse. To summarize, Child Protective Services is dealing with any report of suspected or known abuse of children by the formal definition we'll talk about in just a moment. And General Protective Services looks more at concerns for the welfare of children outside of abuse. Let's now look at what defines a child. This slide may seem silly to some of you, but it's important to think about. When I ask you to think about child abuse, what types of children come to mind? Usually, very young children, elementary school age, are the ones that people think of. It's important to recognize before we continue this program that children are defined all the way up to age 18. This means children that are ages 14, 15, 16, and 17 still classify as a child under the law. Therefore, if abuse is suspected in children of 14, 15, 16, and 17, be it physical, mental, or neglect, those cases should still be reported. Let's move on now and talk about what exactly is child abuse. The legal definition is an act or failure to act that's committed intentionally, knowingly, or recklessly. Recognize that it's not just that you did something, such as an act, but that it's also if you fail to do something in failure to act. Let's look at examples of each of these. Acts that are done intentionally, per the law, are committed when a person consciously engages in conduct of that nature or cause such a result and are aware of such circumstances or believe or hope that they exist. For example, if you would shake and hit a child that will not stop crying, you're shaking and or hitting them with the intent that that will stop the crying. What you're doing is very intentional for a desired outcome. Acts that are committed knowingly, per the law, are done so when a person is aware that their conduct is of that nature or that such circumstances exist and they are aware that it's practically certain their conduct will cause such a result. If you're responsible for a child who comes to you with a swollen, painful wrist that looks very painful, that the child says is painful, and that they're crying because it hurts so bad, and you decide to not get them further attention and treatment, you potentially know that by what you're doing, you could cause more harm to the child, so that would be knowingly. Now, some of you may be thinking of exclusions, such as what if they don't have access to health care? What if they don't have insurance? For now, don't worry about the exclusions, but recognize the definition of knowingly. Things that are done recklessly are done so when a person consciously disregards a substantial and justifiable risk that the material element exists or will result from their conduct. The disregard involves a gross deviation from the standard of conduct that a reasonable person would observe in a situation. For example, if you leave a child in a hot car while you shop, that is considered reckless. It's a deviation from what we would expect standard conduct of a reasonable person to do, and certainly places the child at risk. Please note that it is never your job to figure out if the legal definition is met. This is the job of children and youth agencies across the state. It is only your job that if you suspect abuse to be happening, you report it. Let's now look at the definition of child abuse that is more specifically written out in the law. First, causing bodily injury to a child through a recent act or failure to act. Once again, please note that it's a recent act or failure to act. Therefore, if I'm sitting on my front porch and allowing my small children to play in the busy street in front of me, and one of them gets hit by a car, potentially my failure to act and preventing bodily injury to a child could be looked at as child abuse. Fabricating, feigning, intentionally exaggerating, or inducing a medical symptom or disease in a recent act or failure to act. This would result in harmful medical evaluation or treatment to a child. For example, if a child has not been to school for a week and someone comes to the house to check on the child, and the parents or guardians tell that person that the child has been sick, has been dizzy, can't get out of bed, etc., they of course are going to seek out medical evaluation for the child. Now, if that report of the child being dizzy and sick was not true and was covering up other reasons why the child might not have been at school, and that report does result in medical evaluation or treatment to the child that's unnecessary, that is considered child abuse. Causing or substantially contributing to serious mental injury to a child through act or failure to act or series of such. Well, if you're a parent, you know that just in normal parenting, we often contribute to the mental injury of our children. We don't let them go to a party they want to go to, we say no to a request, and all of a sudden we're the worst parents in the world. Recognize this is not the mental injury we're talking about. We're looking at serious mental injury, which we'll talk about later in our case studies. Causing sexual abuse or exploitation of a child through the act or failure to act. Once again, even if you don't do it, but you fail to do something to prevent it, that is still considered child abuse. And causing serious physical neglect of a child. Now, it's interesting what the law defines next. We've already talked about bodily injury to children, as well as sexual abuse or exploitation. But what we see now is that creating a reasonable likelihood of bodily injury to a child, or creating a likelihood of sexual abuse or exploitation of a child, is also considered child abuse. So not only if you do it or fail to do something that leads to it, but even if you create a reasonable likelihood that it could happen, even if nothing happens, that is also considered child abuse. Next, we look at a list of things that by engaging in them does classify as child abuse. Kicking, biting, throwing, burning, stabbing, cutting a child in a manner that endangers the child. Unreasonably restraining or confining a child based on consideration of the method, location, or duration of the restraint or confinement. Now, we all know that there are various medical procedures that do require children to be restrained. That's not what this is discussing. This is discussing issues that we see in the news of horrific things where children are handcuffed to their beds, are locked in rooms without meals, or even hung up by duct tape from the ceiling. Forcefully shaking a child under 1 year of age, and forcefully slapping or striking a child under 1 year of age. Please note that in these last two, where it says under 1 year of age, it doesn't mean that it's okay for children older than that. But what the state is really trying to say here is that there is no reason to harm and or discipline a child under 1 year of age. They are not able to do things purposefully, and they can't communicate with you. Continuing the list, interfering with the breathing of a child is considered child abuse. Causing a child to be present at a location where a methamphetamine laboratory is being operated is also considered child abuse, as long as it's in an active law enforcement investigation. And causing the death of a child through any act or failure to act. Finally, leaving a child unsupervised with an individual other than the child's parent who the actor knows or reasonably should have known is a sexual offender where the victim's under 18, a sexually violent predator or a sexually violent delinquent child. Once again, we see the definition of child abuse in terms of sexual abuse being very clearly defined in this law. Let's now look at the definition of a perpetrator. In direct acts of abuse, the perpetrator can be the parents regardless of their age, including the parent's spouse, former spouse, or paramour, a person at least 14 years old responsible for the child's welfare for any given period of time, or those living in the same home, including a significant other of the parent. Realize that this does include siblings who care for younger siblings. It also includes babysitters that might be 14 years old or older. And then persons 18 years old or older who do not live in the same home but are related through the third degree, through blood marriage or adoption. These are definitions of people that can be considered a perpetrator in direct acts of abuse. Certainly there are other people that may harm children. While those things are not acceptable and still must be reported, they don't all necessarily fall under this particular law in terms of how they are dealt in the legal system. In failure to act, the definition of perpetrator changes slightly. Perpetrators in failure to act include parents regardless of their age, including the parent's spouse, paramour, or former paramour, and persons at least 18 years old responsible for the child's welfare for any given time or living in the same home as the child. Recognize here that age goes from 14 to 18 in failure to act. This accounts for normal teenage development, where they don't always necessarily have the best judgment for themselves, much less those that they are responsible for. There are many exclusions to child abuse. We will go through them, but remember, it's never your job to determine if an exclusion applies. Environmental factors. Children cannot be considered physically or mentally abused based on injuries that result from environmental factors, such as inadequate housing, furnishings, income, clothing, medical care, that are beyond the control of the parent or person responsible for the child's welfare. So if for some reason a case of abuse is reported and it's found that the parents, because of an illness, loss of job, something beyond their control, can't provide that thing for the child, it will be an exclusion. Religious beliefs of parents. Children are not considered abused who have not been provided needed medical or surgical care because of sincerely held religious beliefs of the child's parents or relative with whom the child resides, as long as the beliefs are consistent with a bona fide religion. In such a case, the county agency will monitor the child and intervene if the lack of treatment threatens the child's life or long-term health. Use of force for supervision, control, and safety purposes. Use of force on or against a child by the child's own parent or person responsible for the child's welfare is not considered abuse if any of the following are true. The force constitutes incidental, minor, or reasonable physical contact to maintain order and control, and the use of reasonable force is necessary to quell a disturbance or remove a child from the scene of a disturbance, to prevent the child from self-inflicted physical harm, for self-defense or the defense of another individual, or to obtain possession of weapons or other dangerous objects or controlled substances that are on the child or within the control of the child. Please know that this law is not intended to restrict the rights of parents to use reasonable force on or against their children for the purposes of supervision, control, and discipline. Contact during physical sports. Participation of a child in a practice or competition where physical contact is made does not in and of itself meet the definition of child abuse. Child-on-child contact or harm or injury from another child. Harm or injury to a child from the act of another child is not considered child abuse unless the child who caused the harm or injury is a perpetrator by the definition we already discussed. Mutual disputes and self-defense. Reasonable force for self-defense or the defense of another individual is not considered child abuse. Please remember that the reports that are filed are reviewed by the County Children and Youth Office to ensure baseline criteria are met relevant to all the definitions we've just discussed, definitions of abuse, perpetrator, exclusions, etc. Those investigations begin within 24 hours of the report, and a decision must be made within 60 days. It is never your job to determine if the definitions are met. That's the job of County Children and Youth. There is no exclusion to making a report of suspected child abuse. If you suspect that abuse is occurring, you must report it. Let's now move to who are mandated reporters. Mandated reporters are those persons required to make a report of suspected child abuse. They include anyone licensed or certified by the state in a health-related field, medical examiners, coroners, funeral directors, employees of healthcare facilities that have contact with patients in the admission, treatment, or care of individuals, school employees, child care service employees, religious leaders, individuals who regularly are responsible for children as part of a program, service, or activity. So that would also include people who volunteer in the church nursery, Boy Scout leaders, Girl Scout leaders, etc. Social service employees, law enforcement officers, emergency medical service providers, public library workers who work with children, independent contractors who work with children, attorneys affiliated with an organization that's responsible for the care, supervision, guidance, or control of children, and foster parents. Please note that the list of mandated reporters is quite long, but it is not equal to the list of those mandated to take this training. There may very well be many people you come in contact with who are mandated reporters, but do not need to take training. We recommend you always encourage mandated reporters to take training so they know what they're being held accountable to, even if it's not required under the new law. Anyone can make a report of suspected child abuse. Those who make a report but are not mandated to do so are known as permissive reporters. The only real difference in reporting is that permissive reporters must use Childline, the phone number we'll discuss later, whereas mandated reporters are encouraged to use the online reporting mechanism. When do mandated reporters act? Suspected child abuse should be reported in one of 4 situations. First, the reporter comes in contact with a child through their regularly scheduled program, activity, or service, and for whatever reason is suspicious that abuse is occurring. Secondly, the reporter directly responsible for the care, supervision, guidance, and training of the child, or is affiliated with an organization that's directly responsible, believes that abuse may be occurring. Thirdly, a person makes a specific disclosure to the reporter that a child is the victim of abuse. The child must be identifiable. Please note that in this case, you do not need to see the child, talk to the child, or validate the report. But if someone tells you that a child's being abused in that disclosure, you must report it. An individual 14 years old or older makes a disclosure to you that they have committed child abuse. In other words, that they are a perpetrator. It might seem rare that this occurs, but it really does. Many times in mental health institutions, also in prisons, people will talk about the things that they do to maintain control in their homes. Sometimes they don't realize that they are perpetrators of abuse, but they share with you what they do, which in turn is a disclosure that they are perpetrators. Other times, people will be very upfront with the fact that they are perpetrators of abuse. Please note that you are still mandated to report in situations 3 and 4 when disclosures are made to you if you're not practicing your profession, but you're volunteering or potentially retired and maintain your license. As another reminder, you do not need to come in contact with the child or even talk with the child or even have solid evidence first. You only need to suspect something's going on to report it. This is often difficult for healthcare professionals, but please remember, it's not our job in this situation to get all the information first. We share our suspicion, and then the county children and youth agencies go through the work to figure out if the evidence is there or what resources might be needed for these families. Communications. Privileged communication between a mandated reporter and a patient and client of that reporter do not apply in situations involving child abuse and do not relieve the mandated reporter from the duty to report. In other words, although our communication with patients and clients is considered confidential, you still are mandated to report child abuse. It is our recommendation at PSNA that if you find yourselves in these situations, you disclose that you are a mandated reporter at the beginning of the relationship when you do your introductions. This way it will not come to a surprise to people you're working with that you must make a report. In addition, it's always good to share with people that reporting child abuse is not always a punitive thing, but sometimes can be used to equip families with better resources and stabilize them. Confidential communication to clergy and attorneys are protected in their respective laws. Attorneys are subject to the professional conduct of attorneys, but please know that clergy, particularly when we talk about communication such as confessional, do have protected laws regarding that communication. Now that we know who mandated reporters are, how do you act? Immediately, you must make a report when you believe that it is occurring in terms of abuse. If you witness it within an organization, you must also notify the person in charge or their designee of the facility. They do not also need to make a report, but in case there are other records that will be needed by the investigation team, the organization must be notified that that request may be made. As mandated reporters, it's requested that you make an electronic report at the website on the screen. They also request that if you need to talk to someone in person, you can call Childline. Remember that permissive reporters should always use the Childline phone number. The law states that if you call Childline, you must follow that phone report with a written report to the County Children and Youth Agency. It has been our experience that oftentimes while you're on the phone with Childline, they will instruct you on what, if any, further information is needed. And remember, there's always organizational documentation. Please check with your organization to know what documentation is needed when and if you report a suspected case of abuse. This is a CY-47 form. It's the paper version of reporting child abuse. This is similar to what you'll find online if you need to file a report. Please realize, although there is a lot of information on this form, you only need to fill out the areas that you know. When you make a report of child abuse, you may not have all this information. You just fill out what you can. If other report information is needed, it must be sent to the County Children and Youth Office within 48 hours of the request. This may include medical photographs, x-rays, hospital admissions, or post-mortem investigations. Your name and contact information as a mandated reporter must also be disclosed. However, it is kept private except when needed by investigating or prosecuting teams. Let's discuss what happens with the report. You make a report to the Department of Human Services, formerly Public Welfare. They then give the report to one of 67 children and youth agencies throughout Pennsylvania. That agency must start an investigation within 24 hours and make a decision within 60 days. The data is entered into a statewide database, and this is helpful to look at trends in identifying and controlling child abuse. You can find this report yearly on the Department of Human Service website. What does abuse look like? There are many different signs of abuse. Some of the signs of abuse are also signs of many other things, so you certainly need to look at the entire picture. Some things may include unexplained injury or explanations that do not make sense, fear of parents or adults, not wanting to leave school or an organization, extremes in behavior, physical or emotional delay, attempting injury to themselves or others, being frequently absent from school, stealing from others, lacking needed medical care, being consistently dirty, not having sufficient clothing for environmental conditions, saying they are home alone often, refusing to take part in physical activities, having unusual sexual knowledge, and running away. We're going to be looking at a case example activity. If you have not already printed the case example sheet, please do so. For each activity, you will answer the following questions. Is there suspected child abuse occurring? What further information would you collect? And would you report it? If so, how? Remember, this is part of the information you will submit to PSNA in order to get your continuing nursing education. After you submit it, we will give you an answer sheet and guide to discuss these situations in more detail. Case example number 1. A nurse educator teaching children about school nursing. You come across an 8th grader in the nurse's office. She's complaining of a stomach ache and appears sick. As you talk with her, she shares that she has to go to her stepdad's house this weekend and is nervous about that. You ask the school nurse about this, and she says something seems to be happening at the stepdad's house, as the student always ends up here before those weekends. She just hasn't put her finger on it yet. Take a moment and answer the questions on your sheet under case example number 1. Case example number 2. As a family nurse practitioner, you see an 8-year-old boy for arm pain after a basketball game. You order an x-ray and find multiple fractures in different stages of healing. Please proceed to your paper and answer the questions under case example number 2. Case example number 3. A neighbor tells you she overheard what sounded like an argument between another neighbor and his teenage son. It appears that the neighbor was hitting the child with a pan. She said she could hear the child asking him to stop. Please answer the questions under case example number 3. Case example number 4. A friend tells you at dinner that in the apartment above her, the parents are quite strict with the children, often leaving them for hours to fend for themselves. Please answer the questions on your sheet for case example number 4. Case example number 5. You are working at a local YMCA. A 14-year-old child and her parents come in to participate in a program. You notice multiple areas of bruising on the child's arms. You ask the child and parents about it. Both admit to the child hurting herself with erasers. The parents have tried to get her to stop, but they don't know what else to do. Please answer the questions on case example number 5. Case example number 6. During routine dental exams at the middle school, one 13-year-old boy is found to have multiple cavities. He says his parents are aware and got him new toothpaste. When asked about seeing a dentist, he says his family does not go to the dentist. Please fill out the answers on case example number 6. Let's talk about a few more issues related to reporting. Protection from employment discrimination. In the new law, you can take action against an employer who may have taken action against you for making a report of child abuse. If you're required to report, you acted in good faith, and you had some sort of action against you because of the report. This protection does not apply if you're found to be a perpetrator or fail to make a report of suspected child abuse. Mandated reporter's right to know. As a mandated reporter, you can get information on the status of your report in terms of the final status, was the report founded, unfounded, or indicated, and the services provided or arranged for the child. This information will be sent to the reporter from the Department of Human Services. Failure to report. If a mandated reporter willfully does not report suspected child abuse, they may be convicted of an offense from misdemeanor of the 2nd degree up to and including a felony. These penalties can include fines and jail time. But remember, failure to report is when a mandated reporter willfully does not report suspected child abuse. It is not that you should have been suspicious when you were not, unless it's completely overt. Thank you for watching this presentation from the Pennsylvania State Nurses Association. Remember that it is a goal of all of us to help protect our children. The child welfare system in Pennsylvania is state supervised and county administered, with both agencies having key roles in the protection of children. There are 11 other states that have similar child welfare systems. The department is responsible for assuring the availability and provision of public child welfare services, providing oversight and technical assistance to each county agency, and establishing and enforcing policies and regulations that support the achievement of child welfare goals and outcomes. Additionally, the Department of Human Services is responsible for the licensure of public and private child welfare agencies and the investigation of complaints received regarding those agencies. Each county Children and Youth Social Service Agency is responsible for administering a program of children and youth social services to children and their families. It's important to remember that we are all in this together. Please feel free to contact us at education@psna.org with any questions you may have.